schools all over. So we see all kinds of issues. It's really interesting work, I think for the same reason you're gonna find very exciting careers in working with kids. Frankly, it's exciting for the lawyers as well, because you'll find that there's no way you can even imagine or come up with the creative ways kids can get in trouble. So whenever I get a call from somebody who works for one of the conferences and I see it's from the education department, I always know it's going to be interesting. I may not have an answer for them because it might be something crazy and new and we'll have to, noodle through it together, but I know it's going to be interesting. So what I'm here to do today is to cover a few really key issues that I think you should know going into this field. And what I'm doing is hopefully putting some seeds in your head so that when you see an issue someday, when you're out there in the workforce, you'll know, hey, this is something that I need to talk to somebody about. You're not going to know all the answers. You're not going to know how to do everything that you may need to do legally from this presentation, but I'm hoping that you'll at least be able to issue spot. In law school, they teach you to issue spot. There's no way a lawyer can know everything. You can't know what every law says. There's too many. However, if you know how to spot the issues, you know when you need to go looking for an answer or get help. So that's what I'm really hoping to be working within either the Seventh-day Adventist system or some other religious school system. Okay? How many of you are looking at working in a public school system? Okay. There are some really important distinctions between the two. Now, when you work for a public school, you actually have a property right. The law calls it a property right in your job, which the government cannot take away without giving you due process. They can't just arbitrarily or capriciously say, you no longer work for us. You have a right to have that job and to only be fired for some good cause. Private schools are a little bit different. They're governed primarily by the contract because since they're not a government actor, they're not a government school, and there's not what the lawyers call state action or government action, the Constitution and its due process protections do not apply to you. So, you often hear people when they get in trouble for something they said will say, well, that's First Amendment, free speech. That doesn't apply in a private setting. That's why you can see employers who can take action against, look at the NFL situation. Whichever side you're on the protest issue, people will say, well, I have a First Amendment right. Technically, not when you're working for a private entity. So the NFL teams reserve the right to decide whether they're going to say what you can and can't say. And they control all kinds of things that people say. They're a private employer, whereas if it was a government agency, they would be restricted by the Constitution from taking action against people without due process and for things that are specifically protected in the Constitution, like the First Amendment giving the right of free speech. So, when you're in a public school, you're going to have especially if you're in a union, you're going to have a bargaining agreement that sets forth all kinds of rights, but you also have the Constitution that backs you up in a number of due process rights. Private schools, you only get what they give you. So you need to look very carefully at what your contract says, because your contract is going to govern what kind of due process you get if they want to fire you. Courts generally look, when they're dealing with private school cases and disputes between teachers and schools, they want to see that there's fairness. But this is a much lower standard than the due process standards involved in a public school. They just want to make sure that the school is treating you fairly, and that they're working within whatever contract they have with you and not violating that contract. So I want to show you this really small print. I know you're not going to be able to read it, but I would just want to highlight a couple things for you. This is it's a couple years old now. There may be some minor changes since then, but this is a contract from the Northern California Conference of Seventh-day Adventists, and this is similar to something that you will see if you go to work for a Seventh-day Adventist conference. There's a couple things in here that are very interesting and important based on what we just talked about. You've got all the biographical issues or information up here, of course, and your status and different things. But when you get down in here, the terms and conditions, it says, for example, teacher agrees to personal conduct in accordance with the rules, regulations, and policies described in the current edition of the Pacific Union Conference Education Code. Said code is by reference incorporated into the contract as fully set forth. So what that means is when you sign this one-page document, you're actually agreeing to everything in the education code that governs teachers. And if you look at the Pacific Union Education Code, there are a number of provisions in there that talk about what types of, there you go, you're signing on to that.
That's the PUC education.
So this may look very simple, but there's a lot more to your contract than just what you see on the one page. And there's a section in there that covers employment, and it talks about, for example, regular status. In a Adventist school, in most, at least in the Pacific Union, you can get regular status, which is kind of akin to tenure in the public system, and that provides you certain due process rights. So just to give you a quick idea about what the private schools, or at least the Adventist system, has done to try to answer what the public system is doing with its First Amendment, or sorry, due process protections and other things, is that the Adventist system recognizes we want to protect our teachers too. We don't have to. Under law, we could hire everybody as at will, fire them anytime we want for any reason, as long as it's not an unlawful reason like a protected category. That's a whole other issue we can talk about another time. But they also recognize that it's going to be hard to get people to work for you if, you know, someone's trying to decide where to go. Well, I can go to a public school and be protected, or I can go to a private school and have zero protections. That's not very enticing. So that's why they've come up with all of these provisions in the education code to give you, by contract, some due process rights that you would otherwise in a public school be entitled to as a matter of right under the Constitution. The church is trying to also provide you with a certain level of protection and procedure and due process, so that if you're going to get fired as a teacher, there's a procedure and a process that you know how that's going to go. You can look in the code, you can see what are the reasons you can be terminated, how that process goes. You have hearing rights, and if you don't like what happens at a hearing, you have a right to an appeal. And so it adds in a number of protections. Very minor digression. How many of you have ever heard of a case called Hosanna Tabor? Has anybody heard that? Okay, that's a very significant case that came down from the United States Supreme Court in 2012. Hosanna Tabor basically was a court case where I want to say Presbyterian, although I think I might be wrong about that, but not Adventist, but someone was teaching in a religious school as a teacher. They had some medical issues. Long story short, they ended up getting terminated. They brought a lawsuit claiming that it was unlawful termination because it was on the basis of this medical condition that she had, and therefore unlawful. And the court ended up saying, she's a minister. Therefore, the Constitution says we can't get involved in her employment dispute, because she's there to inculcate a certain set of values. She has religious training, she leads worship, she does all these things that religious teachers do. We're not going to touch that. So there's a number of private school systems who have actually gone the direction of basically making their teachers ministers, and then they have a get-out-of-jail-free card if they ever need to terminate a teacher. And the Adventist Church, at least as far as I know so far, has taken the position that our teachers are ministers, but we're still going to give them the protections of an education code to the extent that we can, because again, we want people to know that we care about them, we want to treat them well, we want them to have some due process so that they'll want to work for us, because otherwise people aren't going to want to work for somebody who can just let them go at any time. So regular status is that which is kind of akin to tenure in the Adventist system. You can only be released for cause and after a hearing if you request it. Non-regular status or provisional or annual, those are a couple of types of non-regular status. You'll want to look at your contract very carefully. When you start as a new teacher, you're going to end up being one of these non-regular status types rather than a regular status, and the contract tells you how you get to be a regular status teacher and what protections each different category has. Yes?
In the SDA system, usually the non-regular status usually lasts for 3 years. Every year your performance is discussed, and usually at the end of 3 years, the school board will recommend to the conference that you be placed on regular status. But there's about 3 years.
That's
usually.
correct.
Yeah.
There are certain educational requirements, continuing ed requirements, that fill the continuing ed requirements, and I've seen that happen a couple times. I've never understood why, but keep that in mind. You got to keep up with the educational requirements that they're expecting of you. So I handle lots and lots of employment cases. Now you got to remember, I defend the conferences, because I represent them. So I obviously have my own slant and bias. More introspective and recognizing of the realities of the nature of their relationship with the conference. You want to remember that the employer makes the rules. I know, especially in my generation and younger, we don't like that. But the fact is, when you go to work for someone and they pay your check, they're the ones that wrote the contract. They make the rules, and most importantly here, they interpret them too. When you have a difference with your employer about what something means, they are the ones that essentially get to tell you what that means. Now, if they're wrong and you sue them and win later, that's fine. They'll learn the hard way. But generally, there's no real point creating bad blood with your employer arguing over what something means in your contract or in school policy. If the conference says this is what the policy means, that's what's going to happen. You need to uphold the employer's interpretation of whatever the rule may be at issue at school or whatever. The biggest thing that I see get people fired is being a liability risk. Don't be a liability risk. What does that mean? We're going to talk a little bit later about negligence and some of the basic ways that schools get sued. But you got to remember, when you are working in a school as a teacher, there are people who are, whether it's a principal or whether it's someone in the conference office who's responsible for running that school. And of the big picture issues they're concerned about, they're always worried about, what can we get sued for? Lawsuits cost a lot of money. We don't have insurance coverage for all types of lawsuits. We need to make sure that the people who are working for us understand that they can create liability problems for us through their actions, and we need them to, what I call, get it, quote unquote, get it. They need to recognize that what you do matters, what you don't do matters, and it's important that when they're looking at you, you're somebody who is not creating liability risks by being negligent in your supervision or refusing to follow rules, even if you think a rule is unreasonable. One of the things you'll run into with schools is schools have all kinds of rules. The law doesn't require that all of these rules exist. However, if a school has a rule and then doesn't follow it, the school can get in trouble for not following it. Good example, we'll talk about a little later in negligence, but handbooks. When you have a handbook in a school, you got to really make sure that you know what's in the handbook and that you're actually following it. We had a case a few years back where a 17-year-old senior was riding in a car with an 18-year-old senior, and the car rolled and the 17-year-old senior got killed. And the issue that arose was he had left, it's a closed campus, he had left campus with 3 other kids, including the driver, in an SUV, and got in this accident that was caused by the other student driving recklessly. So how's the school responsible for that? Well, the problem is there's lots of high schools that have open campuses, and the schools aren't liable for negligent driving of someone else when it's off campus. However, the school in this case ended up having to pay a lot of money because they had a policy in their handbook that no one remembered that it was their key policy. The policy said when students show up on campus, they have to turn in their keys to the office. When they want to leave, they have to sign out and be given their keys. And so the argument from the plaintiff's lawyer was, the law doesn't require that. However, your own policy says you required that. Mom expected that policy was going to be followed, and then when you didn't follow your own policy, you're now liable, at least in part, for the death of this young man because mom relied on your policies, you didn't follow it, kid got his keys, went out and killed this young man. And so those are the types of things where the schools should be always careful about what their policies are and that they're being followed. And that's why when they have rules and they have teachers who aren't following the rules or who are really indifferent to it, they're worried. Not always because they're angry at the teacher as much as you're a liability risk now if you're someone who has shown you're not able to follow the rules. Remember, it's about the kids and not you. Whenever you have a dispute or a disagreement with your employer, if you're looking out for the kid's best interests, and you know your employer is or should be as well, a lot of issues can be resolved by keeping the focus, again, not selfishly on ourselves or in the same, this goes to the employer as well, not selfishly on them. If it's about the kids and you work cooperatively with your employer, you can resolve a lot of issues before they arise to getting you in trouble with your employer. Be cooperative even in disagreement. There's going to be times when you're going to disagree with your principal or with the superintendent or somebody on the board, and that's fine. There's lots of room for disagreement. Where you're cooperative and respectful, usually that's not going to create problems for you. But where I see people who get really indignant about the fact that someone is not seeing it from their side, and then because they're indignant become a liability risk and don't follow the rules, you're on a road to trouble there with your employer. If you disagree with your employer, just remember rule number 1. They get to interpret those rules as the employer. So you certainly should point out where there are disagreements if you think there's an issue, but you got to remember that ultimately they interpret the rules. So if they tell you this particular rule is what it is, you need to follow it, because if you don't, you're a liability risk, and that's not going to bode well for your future. School liability. Now, there was a time in California and in most states where, as a charity, they were completely exempt. You couldn't sue them for their negligent acts. But over time, the law has pretty much come to say that doesn't make any sense. When somebody sends a kid to an Adventist school or a Catholic school, there's no reason why they shouldn't be held to the same standard that any other school would be held to when it comes to supervising kids or enforcing any kind of safety rule. So essentially, our schools can be liable for all the same things a public school can be liable for. And I'm going to walk you through what a lot of those key areas of liability are. So first, there's 2 things. If you forget you're going to forget most of what we talk about probably. But these are 2 things that are really helpful to remember, and that's why I only put single words, right? Should be easy to remember. You don't even have to remember full sentences. Just agency and notice. Who knows what agency is? Anybody want to tell me what that is? What's that mean? What does it mean to be an agent for someone else? Volunteers? Yes, sir.
On behalf of someone.
Exactly. You're doing something on behalf of someone else, okay? You are or will be an agent of your employer. What that means under the law is that the employer is responsible or can be legally responsible for what you do or what you don't do. Okay? If you should have done something and you didn't do it, your employer can be liable and responsible for that. Notice is the other really key concept. Notice basically refers to the idea or the concept that you know something or should have known something. So a lot of the negligence things that we're going to talk about hinge on agency and notice, because what will happen is something bad happens. Whether the school is liable, we're going to talk about all kinds of rules, but if you remember these, it kind of sums up all the rules to let you know if you have a problem or not. Because if the school has somebody who's working for them that does something or doesn't do something they're supposed to, and they had reason to know or should have known that this person was going to do something bad or was not going to do something they were supposed to do, the school's going to be liable for that. So let's talk about what that means in a little bit more detail. So negligence. Negligence constitutes or I should say there's 4 elements that constitute negligence. Negligence is the most common thing that a school gets sued for. In a civil lawsuit, you can sue people for all kinds of things. Defamation, intentional infliction of emotional distress, violation of privacy. There's all kinds of things you can sue somebody for. But what do schools get sued for? Primarily, you did something or didn't do something you should have done and it hurt my kid. That's the nature of most of the lawsuits against schools. So to be found guilty or liable under negligence in a civil case, the plaintiff has to prove 4 things. They have to breach caused the injury, but you got to have injury. If you can prove all 4 of those, then a jury should award you money for the damages you suffered as a result of negligence. So what are some legal duties of schools? What do you think? What does a school have a legal duty to do? Anybody want to venture a guess? I already mentioned one of them, probably one of the most important ones. Supervise who? Supervise the kids, right? You got to supervise the kids. Adequate supervision. You also need to use competent and proficient personnel. You need to have adequate instruction in the use of equipment. You need to furnish and maintain safe equipment and premises. You need to make and enforce adequate rules. There's all kinds of things that can be alleged, but these are really a lot of the biggies. If you look at lawsuits against schools, These typically sum up the most common ways in which schools can get in trouble if they don't do something they're supposed to do. So right now we're talking about the legal duty. This is something the law expects you as a school, and of course you as the agent of the school, the teachers, to be doing all of these things. Competent, proficient. You got to have people who know what they're doing for whatever the particular task is. There's something called the reasonable person standard in the law. And the law is always going to be looking at what the reasonable person should do in a particular circumstance. Now, if you're going to be teaching a class in English, you're going to want somebody who has some proficiency in English, obviously. There's not a lot of liability that arises in English classes. But imagine now you have somebody who's teaching woodshop. You don't want to send an English teacher who doesn't know how to run a table saw into a wood shop and then start having kids make cuts, because you know what's going to happen. If somebody gets injured, the lawsuit's going to be claiming that you did not have competent and proficient personnel because that person who came out of the English classroom does not know how to run a table saw and did not adequately supervise or instruct the children, and that's why an injury occurred. Supervision's pretty obvious. Adequate instruction, the use of equipment. Think about a gym. Yes.
With this adequate supervision, do you ever get asked or deal with situations like how many students can one supervisor, is it 1 to 15 or 1 to 50?
That's a great question. So it's a sliding scale. Some states have very specific mandates. In a state like California, there are some specifically required ratios under the law. For example, when you're dealing with preschools, I believe it's 12 to 1, if I recall correctly. But as you get up into the years, the older students, it's a question of reasonableness. And so what'll happen is, it's up to your jury to decide what's reasonable, which is always a problem because you never know what your jury is going to say. But you're always looking as a school to make sure you have enough people for the task at hand. If you're going to be teaching kids, let's say you're at a climbing wall, and you've got 40 kids there, and you're going to be teaching them how to climb up a wall and then rappel down. Well, if you got one person there for 40 kids on a dangerous activity like that, probably not reasonable. You need to have enough personnel that someone can be at the top, someone can be at the bottom, someone can be instructing kids who aren't on the rope yet about what they need to do to get their harness on right and how to do everything. So depending on the activity, it's going to differ. As the kids change in ages, it also differs. So an example, we had a lawsuit that we resolved a couple years back where a kindergarten teacher had taken the boys and girls after recess to use the restroom. It's a female kindergarten teacher. There's about 10 kids in the class, 5 boys, 5 girls roughly. She sends the boys into the boys' restroom, the girls into the girls' restroom. They're right next door to each other with exits that come out by each other. And so what she would do is she would stand outside for a little bit, and then she'd go into the restroom to make sure the kids, there's only 3 stalls in each restroom, so she's shuttling kids in and out, right? So she's in and out, shuttling in. And the 2 of the boys that were in the restroom, one of them ended up sexually molesting the other boy. These are kindergartners. So that obviously indicated some issues on reportability, because where did this kid learn to do that? We'll talk about that in the next part of this presentation. However, the lawsuit alleged that she was negligent. She did not properly supervise. She claimed that the school should have had another person available and that the kid should have never been unsupervised. Well, the fact is the law doesn't say what is and isn't right, so that's when you have to get into what's reasonable. And the way a jury understands what's reasonable is you get expert witnesses to come to the trial and testify about what common practice is. So we had expert witnesses who they didn't get to trial, the case got settled, but the testimony would have been the standard of care at kindergarten is not to have enough teacher, it's not to have a teacher in the restroom at all times. It's common practice and reasonable, especially where you're constantly supervising like she was, to allow a kindergartner to use a restroom alone. Now, if those were preschoolers, it would have been unlawful for her to leave kids unsupervised. You have to have supervision at pretty much, you can't leave kids alone together, particularly without constant supervision. That's what the law says. But at kindergartners, you start to have a loosening. And when you get up to the high school level, that scale slides even further. So in that auto accident case I told you about, one of the issues in that case, they also sued the school for inadequate supervision. And the argument they made was, these kids should have never been able to get to the parking lot. Even if they didn't turn in the keys like you were supposed to. Putting that aside, you're still liable because they got out of chemistry class, then they went to the lunch period. Someone should have been supervising them to make sure they actually went from chemistry to the lunch period. And our argument, which I'm convinced is correct, and based on our expert testimony as well, and the legal cases seem to support, is that's ridiculous. You don't have 17 and 18-year-old high school students shepherded at all times and at all times within the sight of a teacher. That's completely unreasonable. At that age, kids are expected to be responsible for themselves, to get from class to class. And if you're going to impose a legal standard that somehow requires constant eyes-on supervision of high schoolers, you might as well shut high schools down. You can't afford to have enough staff to have eyes-on supervision at all times. So, that was the push and pull on that argument. It was all about how many teachers are enough. Do they have to have supervision all the time? And the answer is not a solid answer. It just is a question of reason. And that's where we bring the battle of the experts. We have our experts, they have their experts, and they testify from all their years of vast experience in teaching and supervising schools what is common and reasonable practice and why. That's how that gets sorted out generally. All right, let's talk a bit about the next item, breach of legal duty. So when you talk about breach of legal duty, this is where you got to decide, or the judge or the jury has to decide, did they actually do or not do something that violated this legal duty. So there's a couple of measures by which a judge or a jury are going to decide if you breached your legal duty. First, they're going to say, did you do something that a reasonable person wouldn't have done? Again, reasonable is tough, because what does that mean? There's no legal definition that says a reasonable person will always do A through Z and never do A through Z. You don't know that. You got to convince the fact finder, the judge or the jury, what a reasonable person would or wouldn't do in certain circumstances. Foreseeability is also another test that's really important. So when you're talking about that breach of duty, was it foreseeable that a certain thing would happen or not? So let's take a quick example. You're going to take fourth grade boy, let's call it fifth grade boys, to a dynamite factory. Okay? First of all, you know that you're going to need a lot of supervision at a dynamite factory because you're dealing with really dangerous stuff. So when you get sued because some kids blew themselves up, one of the questions is going to be, was it reasonable with what you did or didn't? First of all, was it reasonable to take fifth grade boys to a dynamite factory? Probably not. Is it foreseeable that they would blow something up if they had the chance? Probably. That's the type of, in a very exaggerated case, that's the type of analysis that a court's going to look at to see, were you providing adequate supervision under the circumstances? In this kindergarten case I told you about, it was reasonable, we believe, and our expert believe, for a teacher to have kindergarten students and shuttle them in and out of bathrooms and go back and forth constantly to supervise them. We believe that was reasonable. Is it foreseeable that kindergartners, one of them is going to attempt to sexually assault another in a restroom stall? Well, that's a closer question, but our argument was that's highly unusual behavior. There is sexual exploration and things like that happen at fifth graders, but fifth grader, I'm stuck on my old example, kindergartners. It's highly unusual for a kindergartner to attempt certain aggressive sexual acts on another kindergartner, especially when their window of opportunity is so low. I mean, they're only unsupervised in there for up to 45 seconds to a minute and a half, depending on how long it's taking the teacher to get back and forth. So those are the kinds of questions a jury has to look at and say, did they breach that legal duty to provide adequate supervision? Assuming the jury determines that yes, they breached a duty, now, was that breach the actual cause? So it's defined as a logical and sequential connection between the school's breach and the student's injury. So some of the ways that this can be stated is, the plaintiff must prove that the injury would not have occurred but for the breach. The injury must be the natural and probable result of the breach, and there is no intervening cause. A couple of interesting cases to illustrate the point. These aren't cases I had, but this is case law from some other schools. School bus shows up in the morning to take kids to school. One of the kids is acting up. The school bus driver refuses entry to the kid who's acting up, says, you can't ride the bus today, go home. So the kid goes around his house, gets a bicycle, rides the bicycle to school, gets hit by a car, severely injured. The lawsuit is, you didn't tell the parents. This child, I forget what grade this child was in, but the child was in a lower grade. Parents are saying, you can't boot a kid off the bus or not allow a kid on the bus and not tell the parents. That's negligence, because it's very foreseeable that the kid is left to his own devices after the bus drives away is going to do something that's hazardous. So in that case, the jury found that the school was negligent. They should have notified the parents when they refused entry to the bus, and they were liable for this third party's negligence, who also would have had some liability responsibility for hitting the kid on the bicycle. The school had liability for that as well. Another case, which was an interesting case, involved a situation where a student, for whatever reason, a teacher lied to a student and told the student that he had failed the test. The student got very upset. This was one of the last classes of the day. The student finished the class, went to his locker, got his goodies, did whatever, and then on his way home, got injured in a car accident. The student was driving, got injured in a car accident. The parents brought a lawsuit claiming that the school was liable for the lie, which triggered this set of circumstances because it got the student very upset. The student was not paying attention when they were driving due to being so upset about failing a test that they never failed in the first place, and it was a lie, and had they not been lied to, this would have never happened. In that case, the jury said, no, school's not liable. The student's liable for his own inattention and driving, even though it may be related. This is not something that's foreseeable, and they did not hold the school responsible. But you can see how that scenario could change. What if you had a situation where the teacher lied to a student, and the student got so upset that they ran out in the street, like right there, just maybe, are you serious, and stepped off the sidewalk and got hit? Okay, you've got a closer proximate relationship. A case like that, maybe a jury would find differently. And remember, never forget, that jury in that case, you could have tried the exact same case with the exact same lawyers and the exact same witnesses, everything carbon copy of each other, and the next jury could have found something completely different. I've watched juries deliberate in jury exercises. Some of our really big cases where we have high liability, we will hire companies to come in and actually, they pick real people from the real jury pool from the jurisdiction where we're going to try a case. And we put on a mini trial in front of them. They think they're actually doing what's called an alternative dispute resolution. They know they're not in a court, so they know it's not a real court. But we tell them, you are deciding this case. We're putting on the case in front of you. You're going to go and deliberate, and you're going to decide this case. Now, they're not actually deciding the case. What they're doing is they're reaching a decision, but then we analyze their decision as well as how they reached it to know what our weaknesses are in the case or what our strengths are, to try out novel arguments. So I've watched many groups deliberate deciding cases, and the things that they make up their minds on is quite scary. I have to say, it's the best system there is. I'm not saying there's a better system, but in a lot of cases, I would almost prefer a judge to decide my case than a jury, because you wonder, like, where did they come up with that? It's some pretty wild stuff. So we try and do the best we can as teachers and administrators, because you never know what a jury is going to do to you. Injury. There's got to be an actual injury. I tell this story every time, but I have not found a case to beat this case yet. Actual injury must exist. I had a case with a kid who sued a school for being pantsed in PE, and he claimed severe emotional distress because his class saw him in his underwear during a PE class when a couple other boys pantsed him. And he wanted $4 million for his emotional harm on that case. What was interesting about that case, aside from the fact that that's a totally ridiculous monetary demand for the type of injury he's claiming to have sustained, when I was interviewing his classmates, it turns out that he regularly mooned the class on his own volition, bare-bottomed. So the argument quickly became, explain to me how you're emotionally traumatized to the point where you need all kinds of psychological care and you need $4 million to pay for it because the kid saw your underwear, when you at least 10 times this year alone have pulled down your own pants in front of the class when the teacher was out of the room, showing your bare bottom and genitals, frankly. That case went away very quickly after that for $0 because there's obviously no case there. The point I'm bringing up, other than to tell a funny story, is that case really, there's no actual injury there. The emotional distress that he was claiming, he couldn't support with any counseling records, medical records, etc. He was just upset. His parents were crazy, so they wanted $4 million. Defenses. Remember that story I told? Well, we'll get to that. Consent. Assumption of the risk. You know, how many of you have ever been bungee jumping or go-kart driving or horseback riding or anything like that. Most of us have done something like that. You ever read the releases that they have you sign? You always sign a release, right? What they're trying to do with those releases is to create an assumption of the risk argument that you knew and appreciated the risk that resulted in the injury. So the way this comes out is if you have if you're going to go horseback riding, if they've drafted the release correctly, they're going to go into all the grotesque detail of what can happen to you when you ride a horse, like falling off and cracking a skull, or getting killed, getting hung up in the reins, and they want to basically put everything they can think of in there so that later on, if you try and sue them, they can say, whoa, you released liability and you signed up for this because you said you recognized how you could get hurt and agreed you were not going to sue us. You were assuming that risk. So that's why a lot of our schools will have waivers and assumptions of risk forms signed by kids and parents for extracurricular activities like football and other PE sports, or if they go on field trips, we'll ask for releases from field trips, things like that. Comparative negligence is a concept in the law that deals with assigning percentages. So remember the case I told you about where the kid was refused access to the school bus and he's riding home on his bicycle, then gets hit by somebody in a car. The way the courts decide who's going to pay is comparative negligence. Different states do it differently, but in California, it's an absolute comparative negligence state, which basically means the kid's, let's say he's got $100,000 of damages. The jury is going to have to assign a proportion of fault to each of the school and the guy who was negligent by running the kid over on the bike. And they're going to say, okay, well, we think the school's 30% negligence and the guy who was driving the car was 70% negligent. And so that means that the guy driving the car is going to pay $70,000 and the school's going to pay $30,000. That's how that works. So when we're defending claims, we're always looking for who else played a role. And then there's always an argument about who shares what level of responsibility for the harm. Negligent hiring, supervision, retention. These are the most common claims against the schools that we defend. And generally, if some child gets injured, it's usually a result of a teacher who did or didn't do something they were supposed to do. So the schools will get sued saying, hey, for example, you hired a guy who had a criminal record for child abuse, okay? And you were negligent when you did that, because obviously if you hire somebody with a history of child abuse, you knew or should have known, again, it's a notice issue, that this guy was a threat to kids. So we're going to come after you for negligent hiring. Negligent supervision is a case where you'll say, okay, you didn't adequately supervise your kids or your employees, and this abuse occurred because you weren't paying enough attention. So the fact that you were not careful in your supervision, you were negligent, it led to harm, and that's one of the types of causes you'll see. Negligent retention. Let's say that you have a teacher who assaults a child, knocks out a kid. The school says, well, you know, that kid kind of deserved it, and then puts the teacher back in the classroom with no discipline, no counseling, no nothing, does not fire the teacher, and then next month, teacher knocks out another kid. Kid gets really injured and the school gets sued. The argument here is that you were negligent in retaining this teacher. This teacher had punched out a kid before. You knew that this teacher was a threat, and you didn't do anything to try and mitigate that threat, so your negligence led to the harm of this other child by failing to take action against this teacher. So that's just in a real quick nutshell how those claims work, what they look like. Now, some of the most common questions that come up for people who work in schools, of course, is going to be, can I get sued individually? Meaning, who gets sued? Is it the school or is it me? Usually both of you are going to get sued. However, in most cases where you're just performing your job functions, even if you're negligent, if you make a mistake and a kid gets hurt, you're still not supposed to be sued individually, and we can usually get you dismissed as an individual defendant. It's the school. Remember, you're their agent. So the school's responsible for your actions. If you get sued individually, we can usually get you out. However, what are you going to do in the interim? Will you get defended? Yes, the school will defend you, and in most cases, the same lawyer, meaning me, will be defending the school and the teacher in a lot of cases. In cases where there's a sexual abuse claim, we usually get their separate lawyers. So the teacher will have their own lawyer, the school will have us, And either way, there'll be a defense for the teacher. You got to remember, anybody can be named in a lawsuit. You can sue anybody for anything in the United States. Whether it goes anywhere is the question. In most cases, no. Frivolous lawsuits are going to get dismissed by various types of motions that lawyers can file. But these are the things that kind of matter, or do matter, when you're looking at whether you might get named. Were you acting within the course and scope of your employment? So, an example is when you punch a kid because you got mad at the kid, that's actually not in the course and scope of your employment. You're not hired to punch kids. That's not part of your job duties. So that's an intentional act, and in most of those cases, you can be named as an individual, and whether the school provides a defense for you or not is dependent on the particular case. But if you are supervising kids, like that kindergarten case in the bathroom I told you, and then it ends up being an injury, you're acting in the course and scope. You're doing your job at the time of the injury. It's just a question of whether you were doing your job well or not. We hire you to supervise. You didn't do a good job supervising. Okay, it's within the course and scope. You're going to get a defense, and you shouldn't be named as an individual. It's going to look at whether you're exercising the reasonably prudent, the degree of care that a reasonably prudent parent would use, and also whether there's any kind of higher degree of care that's required. These are the types of things that, again, can decide whether you're going to get named as an individual. If you're doing your job, course and scope, and you're doing it within the usual expectations of someone of your experience and training, you should not be an individual defendant. You're just an agent who, maybe you fell down on the job one day and somebody got hurt. Those things happen. But if you were doing something intentional, like, again, attacking a kid because you got angry and lost your temper, that's going to lead to a potentially different result. All right, let's talk about child abuse. Boy, the time flies. We're going to fly through this piece because I want to have some, actually, any blaring questions from what we just covered? I'm sure there's probably a lot, given how much material we cover in a short amount of time. But anything you just got to ask right now before we move on to child abuse? I see a half raised hand there.
I'm trying to remember.
You can raise your hand later if you think of it.
Mm-hmm.
Okay, child abuse, identification, reporting, and prevention. I'm going to cover the high points here. This is very important to you because you are a mandated reporter and because you should care about the protection of your kids. What is a mandated reporter? Have any of you heard yet what a mandated reporter is? I'm guessing most of you know what that is. What is it? Sir in the back with the hat. What is it?
Whatever you see, if it's any sort of danger within the students, if like they show signs of being abused in any sort of way, you are mandated by law to report it.
That's right. So what happened was people used to often not report things that they should have reported. And so most states started adopting mandated reporting statutes that say, okay, we're going to make it a crime to not report. And not only that, we're going to provide immunity for people who do report. So it's a double-edged sword, or I guess I should say it's a sword and a shield. It's against the law to not report, but if you do report, we're going to protect you from getting sued by the person you reported or anybody else who's trying to claim that you did something wrong by making a report. Mandated reporter, teachers have to report known or suspected child abuse to proper authorities. What is reasonable suspicion? California's law says you will report once you have a reasonable suspicion. For purposes of this article, reasonable suspicion means that it's objectively reasonable for a person to entertain a suspicion based upon facts that could cause a reasonable person in like position, drawing when appropriate on his or her training and experience to suspect child abuse. Okay? Really important point, which a lot of people have trouble with. Your duty is to report, not investigate. A lot of times, someone in a classroom, a teacher or a principal or some other administrator, will get information that there's something wrong or they'll see something. But they're not real sure, so they don't know what they should do about it. The law, reportability aspect of the law triggers at the point there is reasonable suspicion. There's a lot of times on the part of administrators kind of a need, and I get it, it's your job to deal with issues and find things out and act accordingly, that you want to know whether or not you're going to make a report on someone that isn't true, right? You want to know if you're going to report somebody for abuse, that there was abuse. You're violating the law if you have to run yourself all the way from I just heard something to now I'm convinced abuse took place. The moment at which you have a reasonable suspicion that abuse took place, your duty is to report. You shouldn't investigate. You don't have a duty to investigate. You shouldn't investigate further. Now that doesn't mean that there's something wrong with asking some questions to form or solidify the reasonable suspicion, okay? If someone comes to you and says, so-and-so got abused by their dad this weekend, and you have no reason to, you have no other information, and maybe the person who told you that isn't very trustworthy, do you have a reasonable suspicion at that point? Maybe not. Is it appropriate to say, okay, well, why do you say that? Who told you that? And okay, now you've asked a couple more people, oh, you know, there's a couple kids who say that this kid told them that. At that point, you probably have a reasonable suspicion. It's time to call. You don't need to go interview that child and interview the parents and make notes and then make a finding and then call. You're going too far at that point. So duty is to report, not investigate. Report once you have that reasonable suspicion. I'm not going to cover all of the specifics of what child abuse is because particularly in this day and age, a lot of us are going to know what these are, but child abuse in California is defined as physical, sexual, emotional abuse, and neglect. Physical abuse generally is any non-accidental act that results in physical injury. Sexual abuse is something that is a sexual assault or sexual exploitation of a minor, and it includes a lot of obvious things: rape, incest, sodomy, oral copulation, penetration, child molestation. Emotional abuse, it's actually, I think it's pretty common. It's not often that that's the type of abuse you'll need to report, but we have had a couple cases where we've had schools who have reported either staff members or parents for emotional abuse. And what does that mean? It's verbal assault, belittling, screaming, threats, blaming, unpredictable responses, continual negative moods, constant family discord, double message communication. When is it reportable? It's reportable when it appears to constitute willful cruelty or unjustifiable punishment. Neglect. The classic cases you'll see in the training literature deal with children who are malnourished, children who live in upstate New York and they show up to school in January without shoes and a jacket. Okay, that's the type of thing that would be reportable under most reporting statutes. What is not child abuse? Most of the time, kids fighting is not going to be considered reportable child abuse. This really, I'm thinking, probably should say what is not reportable child abuse, but voluntary sexual activity between children under the age of 14 in California generally is not in and of itself reportable child abuse. Pregnancy of a minor, regardless of age, does not in and of itself constitute the basis of a reasonable suspicion for child abuse. Reporting child abuse. Okay, this is what kind of where the rubber meets the road. The law in California says you have to report it immediately. Once you have that reasonable suspicion, you need to report it immediately by telephone to either a protective agency or law enforcement. You must follow with a written report. There's a DOJ form. You can get it from your school. You have to write out all the information that they ask for there and submit it. Let me nutshell this for you. So, some really important notes that I think will help you a lot. This is something that is important to remember, particularly the third point. You do have immunity for making reports. I have not handled these cases, but I'm aware of cases in the Adventist system where someone in the school reported someone for child abuse, and then the person who was alleged to have done the abuse sued the person for defamation. California actually has a fund. You don't even have to pay your own lawyer. California will pay your lawyer to defend you. And that teacher got a defense paid for by California and won her case. The law is very protective of reporters, so don't be afraid to report because of what might happen to you legally. You're much better off making a report than not. Another thing that's really important to remember is the duty to report is individual. So what this means is if you're a teacher and you go to the principal and say, I think there's a child abuse issue here that needs to be reported. If your principal tells you, you know what, you're right, I'll take care of it, and then you say okay and walk away, you're running the risk. If they don't file that report, you can still be criminally liable because you have a duty. The principal has a duty as well, but you still have a duty. You are not absolved by telling someone within the system. Your duty is not satisfied until the report is made. So make sure that whoever you're dealing with who says they're going to report it, if you believe there's reasonable suspicion, you got to make sure they reported it, or you got to make sure you report it yourself, because you don't want to be in a situation where you violate the law by not following through on the report. This is, if you remember nothing else, this will bail you out in many circumstances. When in doubt, or on what I'll call a wobbler, where you're not really sure, call the cops and ask them. You don't have to call them and say, I'm reporting John Doe for abuse. You can call them and say, I'm a teacher at such and such school. I'd like to run this situation by you to see if this is reportable. I don't know. This is what I've heard. And I've had a lot of situations where an administrator or teacher, they're not sure if they even have reasonable suspicion, but they don't want to leave something, right? They don't want to just walk away from it because they don't know the answer. So a lot of times what they'll do is they'll call the cops and say, this is what I'm dealing with. This is what I heard. I don't really know what to do. Is this reportable at this point? And then do what they tell you and document it. So if the officer that you're speaking with tells you this is something that's reportable, we'll send someone down, then make a report. If they tell you that's not reportable, handle it internally. Okay, document who you talked to, what they told you, and then deal with it internally. And again, if you're dealing with something internally, meaning, okay, we're going to have to talk to somebody here, maybe there's going to be some discipline or employment consequences, and during the process of dealing with it internally, you learn more information. Okay, well, call the cops back and say, you know what? Thank you very much for the advice before. We talked to the employee. We've now learned this. What about this? Is this reportable? You want to make sure that you're creating a record. And the reason why that's really important is the plaintiff's lawyers, when a school gets sued for sexual misconduct, the plaintiff's lawyers always have the benefit of 20/20 hindsight. So they're going to be looking back on your case, sometimes 2, 3, 4, 5, 10, 15, 20 years later, depending on the statute of limitation in your jurisdiction, passing judgment on what you did or didn't do. And it's really easy to make you look bad when they know that this guy turned out to be an abuser, and that had you done something at this time, you could have prevented it. Whereas you're in the fog of war at the time, right? You don't know anything. You don't have any information. All you have is maybe this thread of information that you're wondering what to do with. When you're in your deposition, I've seen it happen a number of times, and that plaintiff's lawyer is trying to make you look like a dirtbag for not caring about kids. It's really nice when they ask you, well, what did you do? You did nothing. What did you do to protect that child? You didn't do anything. Say, well, actually, no, I called the police and I talked to Deputy so-and-so on XY date, and they told me to do Z, and I did Z, and that's it. It really deflates the sales when you do that. So you're protecting yourself and the school by, when you got a wobbler, don't just say, well, I don't know, and walk away. Make that call. You've got immunity. You're going to be protected. Call them and ask them, see what they say, and then follow their advice. You're going to go a long way towards protecting kids, protecting yourself, and protecting your school. Does anybody have any questions on the child abuse reporting aspect that we've covered? Okay, let's talk about protecting yourself from false claims. I have a child abuse presentation I do to teachers and pastors and various other groups, and it's, if you do the full program, it's about 3 or 4 hours of all kinds of material, and the statistics are very interesting. But one of the things that comes up in that presentation is the question of false claims, and how many false claims are there? There's people all over the map. There are those who will say there's never a false claim. You should always believe a child. And there are those who say there's a lot of false claims. The statistics seem to show that with the younger children, the false claims are a lot more rare. I don't remember the exact numbers, but you're talking very low single digits percentage-wise when you're dealing with kids who are like, 10 and under. When you're dealing with kids when they're getting into their teen years and older teen years, the statistics get as high as possibly 10 to 12% or so of claims that are false. In our experience, it's hard for me to estimate the number of abuse cases I've dealt with over the last 15 years or so, but it's definitely been, close to 200 probably. And of those claims, I would say, I don't know, right? Because some of them may have been false, we'll never know. But we know there were at least 3 that were definitely false, and probably another 3 or 4 that were pretty likely false. and then some others that wouldn't have shocked me if they were false, although they seemed like they weren't. There's no way for us to ever really know. The point is, false claims do happen. The horrors, in fact, I've clipped a couple articles from newspapers and from Dear Abby columns and things like that of interest where students have admitted or kids have admitted to making false claims for whatever reason. One of the ones that really was traumatic to me, I guess, for life, not really, but something that definitely kind of freaked me out was there was a kid who was making an exchange with his real dad and his mom and stepdad at an airport, right? He had to fly to his real dad. He didn't want to go to his real dad's, and he was old enough to be traveling without an adult present, but young enough to have exceedingly poor judgment. And this student, or this child, was so upset about having to go back to his real dad that the only thing he could think of to be able to get out of doing that was he went into a public restroom, got the idea of accusing a stranger in the public restroom of touching him inappropriately so that he could get out of going to his real dad's, not understanding the consequences to this other person's life. So there's just some dude in the bathroom minding his own business who next thing he knows, he's getting handcuffed by the cops and questioned for molesting a kid in a public bathroom in the airport. Now it all got sorted out, thankfully. The kid admitted to making the claim and why, but stuff can happen. The point I want to make to you is that, especially for the males, statistically, there are plenty of wrongdoing that occurred by women, but for the most part, the actual abusers seem to be, and the statistics seem to indicate that it's primarily a male issue. Really watch yourself. Looks like we got a power outage. This is on, so I don't know what happened there. But
That has a battery
oh, it has a
backup.
battery. Yeah, my computer's battery too. So we don't need the slide. If you go to work for a school that does not provide windows to your classroom, or does not have windows to in the doors in your classroom, or your office does not have a window, insist on them putting a window in for you. I can't tell you the number of cases and claims we've had that have been defeated and false accusations revealed by the fact that there were windows, and the stories that were given were really not believable or practical based on the circumstances of the environment. So don't put yourself in situations. Don't be alone with students of the opposite sex, preferably not even alone with students of the same sex if you can avoid it. You want to try and always have another adult present if you can. Don't put yourself in compromising situations. One of the classic examples of what happens is, especially when you're a younger teacher, you're going to go to a school, students are going to be potentially infatuated with you, they're going to want to be close to you, they're going to want to spend time with you, they may have opportunities to be alone with you and they're going to seek those out. Don't put yourself in positions where claims and accusations can be made. We had a case not too long ago with a teacher at a school in Southern California who was in a room tutoring a young lady alone, and I don't have time to go into the details of the story, but he claimed that the accusation was false, and frankly, based on what he was saying, he may have been right. But the problem was that he was alone in a classroom with a student, putting himself in situations where it was very easy to be accused and he had no defense. So just be mindful of where you are, who you're with, what you're doing. You're going to find students are going to want to confide in you. If you're a guy and there's a girl who wants to be alone with you to confide in whatever family problems she may be having, seeking you out as someone who's a mentor, either work with another adult as you address those issues or refer them to a female staff. It'll go a long way to protecting you. And the thing that is really difficult about our system right now is, and I think it probably has to be this way, but you've heard the concept that you're innocent until proven guilty, right? I mean, we all know that's a fundamental bedrock principle of United States law. That's the fact of the matter. But the reality of the matter is, when it comes to a sexual misconduct claim, you can be as innocent as the wind-driven snow. If there's an accusation against you, there are very few people's careers who can survive an accusation, false or true. So do the best you can to avoid them. Exercise restraint with physical contact, side hugs where you can. Try not to get engaged in any physical way to the extent you can avoid it. We had a situation where, this just kind of give you an idea of some of the negligence concepts we've talked about. We had a situation with a case where there was a 17-year, 10-month volleyball student or student who was on the volleyball team, and she was TAing for the volleyball coach. So they were alone a lot. He had an office in the gym. They were in there a lot of times with no one else present. And rumors started to go around the school that there was something inappropriate about this relationship. So the administration immediately spoke with the teacher and the student separately and said, hey, we're getting some information, or we're hearing rumors that there may be something inappropriate here. What's going on? Is there anything going on? Which of course they both vociferously deny that there was nothing inappropriate. But the school, out of an abundance of caution, said, okay, you're not going to be this teacher's TA anymore. We need to make a change here. So the parents of the young lady came to the school just outraged over the fact that the school would punish their daughter by removing her as a TA. And that was a big hoopla, and the administrator really got dragged through the mud. But he said, look, I'm sorry, but we felt that this was best based on the fact that they're required to be alone a lot together in situations where they're unsupervised and the rumors are flying. It would not be prudent to have her continue as a TA. So this is what happened. Despite the parents' protestations, the school kept its decision in place. A couple more months go by, and the rumors continue to fly and actually increase. These two seem to still be together a lot, seen around campus. They're there early on campus. They're there late. So the administrator goes to the teacher and student and again asks, hey, what's going on? This is the information we're getting. And they said, no, this is ridiculous. Nothing inappropriate happening here. The administrator, out of an abundance of caution, says, okay, well, given the fact that there seems to still be some issues here, we're asking that you guys keep distance. I don't want to hear about you guys being anywhere alone together or being here early or being here late. And if there is, it's going to be a problem. Well, within 2 weeks, the administrator shows up on campus and sees the teacher's car and the student's car on campus, questions them. They deny any inappropriate conduct. But the administrator says, okay, well, we're done. Teacher's fired. You have not followed directives. You have been informed about the litigation risks that you're presenting, even though you claim innocence. Now we've got an insubordination issue. So the teacher, this is around December or January, teacher is terminated, teacher leaves. The student drops out of school, moves in with the teacher. Turns out they'd had a relationship for about 4 or 5 months, sexual relationship, and mom and dad promptly sue the school. The theory is that the school didn't do enough to protect their daughter, when of course our argument is, you tell us what more the school could have done. You were in here complaining when we removed you as the TA, or removed your child as a TA. We issued directives and we actually fired the teacher with no indication of wrongdoing, just rumor and innuendo and a refusal to follow directives. And so that lawsuit ended up not going anywhere. About 2 years later, the young lady ended up leaving the teacher. They got in some kind of dispute. One of them cheated on him with the other. I don't remember what happened, but the student left. Then the student reconciled with her parents, brought her own lawsuit, claiming that the school didn't do enough to protect her. Now, a couple of things that I thought were interesting in this case. The administrator did, in our book, everything right. He was very proactive. He escalated the actions the schools were taking. We were able to demonstrate. This is one of those cases where we did a mock jury exercise like I told you about before. This is one of those cases where we did where our argument was he did everything right. He was very proactive. And the teacher did everything wrong. That teacher, let's assume for a moment that there hadn't been a relationship. That teacher would have kept his job if he'd been receptive to the school's concerns about appearances. And he may not like it, but had he been more active in trying to maintain separation with that student, he would not have been fired. But instead, he just continued to do what he did and ended up getting fired. The lawsuit claimed all of the above, right? Negligent supervision. They made arguments that they knew this teacher had problems from prior employment, which that was debatable, but they were claiming that he had had an incident with a complaint from a student at the prior school, and that the school that now had hired him and fired him should have known and should have never hired him. So that's what the negligent hiring case looked like. They were claiming the school negligently supervised the teacher. You shouldn't have let him be in a position where he could manipulate or sexually abuse kids. And one of the arguments there had to do with windows. Hey, school, you didn't put a window in his door. What are you doing? You're putting a male teacher and a young girl in a classroom with no, or in an office with no window in the door, in a gym where no one's present. That's negligent supervision. So that's what the negligent supervision looks like in that case. And then negligent retention. They were claiming that you should have fired him earlier. You know, you knew that you were having these issues, or issues were beginning, and you didn't take action fast enough. So that's what a negligent retention claim looks like. And so that's just kind of a nutshell of how these cases can arise, how they can unfold, what the schools can be sued for. And in this case, because the school had been very proactive, had done pretty much everything they could under the circumstances, and they could never prove that the school had prior knowledge or notice of any wrongdoing or misconduct, the case settled for a very small sum. It did settle, you know, they didn't get zero, but legally they got pretty close to zero. They got what's called nuisance value. At a certain point, the insurance company says, if we try this case, you have all the risk of trying a case, plus all the money you're going to spend defending the case. Sometimes it is cheaper, as annoying as the system may be, it is cheaper to pay off a claim, even if it's for a small dollar, to make it go away. And that's what ended up happening in that particular case. But the lawyers spent more in costs from what they recovered from the case. So it was not a winner for them. Everybody went away from that case a loser. Does anybody have any questions or comments about any of the negligence concepts we talked about, or any of the supervision issues, any of the child abuse issues, best practices, anything like that? There's a lot of material that could be covered in a very short amount of time. This you could spend probably 3 or 4 solid days covering the types of stuff we're going over right now. Yes, sir.
I would like to give each of them a chance to kind of tell you what is the takeaway.
Okay.
And so let's just do this lightning round. I've been seeing a lot of notes being taken, so I suspect there's not going to be any lack of takeaways. But could we go around the room, maybe starting with Gloria, and just give example of a takeaway for you today?